Dying declaration. The exception of a dying declaration means if a person was being say stabbed by someone, and then before the person died, the person made a statement as to who actually caused his death. That would be a dying declaration. That statement made by the person, for example, maybe the person would say, Sam stabbed me. And then that statement, if say the person actually said that to a nurse, and then the issue is whether the nurse could come to court to testify as to this statement. This statement, Sam stabbed me, of course, would be hearsay. But this statement would be admissible under this dying declaration. But we need to understand this application of this exception of a dying declaration is limited. It is not in all the cases. If a dying person made a statement, the statement would be admissible. As we can see, in the first requirement for this dying declaration, that is, this dying declaration applies only in homicide cases. So that is important for us to remember. It is not if a dying person actually made a statement as to who committed a robbery or who committed a sexual assault. Those kind of statements would not be admissible because this exception applies only in homicide cases. And then the second requirement is when the person made the statement, the death was imminent, meaning is the person actually knew he was going to die, and then he made a statement. We believe what is the circumstantial guarantee of trustworthiness? We just believe if before a person would die, usually the person would not tell a lie. So that's why we require the death was imminent. And the third requirement is the statement was about the cause of or circumstances surrounding his impending death. It is not whatever the person said would be admissible under this exception. Only the statement regarding the cause of his death or the circumstances surrounding his death would be admissible. So if we understand these three requirements, we understand the application of this dying declaration is very limited. It is very important for us to consider this issue, that is hearsay exceptions and the confrontation clause. We already discussed in the Sixth Amendment to the U.S. Constitution, we have this confrontation clause. Based on this confrontation clause, anyone who is accusing the defendant of committing a crime must be in court to testify in person so that he can be confronted and cross-examined by the defendant. That is an absolute requirement. If the person cannot come to court to testify, the person's statement simply cannot be admitted. It really doesn't matter if maybe the victim is in the hospital, the victim could not come to court. But if the victim could not come to court, and then the victim's statement cannot be admitted, because that's simply because the victim could not be confronted by the defendant. So let's look at these two examples. And in the first example, Ted is on trial for criminal assault, for stabbing Peter. And then in this case, Peter wants to say, Ted stabbed me. For Peter's statement to be admissible, Peter must come to court to testify so that he can be confronted and cross-examined by Ted. that is required by this confrontation clause. So that is the first case we have here. But let's in the second case, and let's say, suppose Dad is on trial for murder, for killing Peter, and then when dying, Peter said to Nancy, "Ted stabbed me," and after that, Peter just died. And then in this case, of course, we know we have this exception of a dying declaration. Nancy, according to evidence law, Nancy can testify about Peter's dying statement under this exception of a dying declaration. But we know we still have an issue of a confrontation clause because in this case, Peter actually was accusing Ted of committing a crime. But Peter would not be available to be cross-examined and to be confronted by Ted at this criminal trial. So how can we solve this constitutional law issue? So that is what we mean by in these hearsay exceptions. Not only we have these hearsay exceptions issues, we also have this confrontation clause issue. If a person is accusing another person of committing a crime, even though that statement would be admissible under one of these hearsay exceptions, but we must consider how can we satisfy this confrontation clause requirement. That is an issue the U.S. Supreme Court addressed in this Michigan versus Bryant. In this case, the victim was shot by the defendant, and after that, the victim actually managed to get to a gas station. Over there, someone called 911, and police came, and police asked this victim what happened. And then the victim actually told the police the defendant shot him. And then the issue would be whether the police officer could testify in this defendant's trial as to this victim's statement. The victim actually named the defendant, saying that the defendant actually shot him, and then whether the police officer could testify as to this statement. We know we have two issues here. One is evidence law issue. Meaning is this victim's statement about who actually shot him would be a hearsay if offered in evidence. But this statement would be covered by some hearsay exceptions. This statement actually could be covered by this dying declaration. It could also be covered by this excited utterance, because the victim was shot while the person was making the statement. The victim was in an excited state of mind. So this excited utterance exception could also apply. In this case, it is important for us to know the prosecution did not ask the statement to be admitted under the exception of a dying declaration. So the statement was only admitted under excited utterance. But that is only the evidence law issue. We also have this issue under this constitutional law. Meaning is, how can we satisfy the requirement of this confrontation clause requirement? The victim died, and how can we solve the issue the victim could not be confronted, could not be cross-examined? How can we solve that problem? The court said, if a person is going to testify, and then the person must be confronted. So the important issue is the key words we need to pay attention to is to testify. So to testify, that means the person would make this testimonial statement. So the court said, in the case, whether we would have this issue of a confrontation clause depends on whether this victim's statement is testimonial. The issue is whether we would have this confrontation clause issue depends on whether this statement in question is testimonial or not. A statement is not testimonial if the primary purpose of the statement is to enable police assistance to meet an ongoing emergency. Meaning is if the victim made a statement, if the primary purpose of the statement was to enable police providing emergency assistance, and then that statement would not be testimonial. But if the primary purpose of the statement is to identify the perpetrator, and then that would be testimonial, because if a witness would go to court and then the witness would say the defendant committed the crime, we know that is a testimonial, because in that situation the witness would be identifying the defendant as the perpetrator of the crime. So that is a testimonial. So in this out-of-court statement, the court is going to apply the same standard, whether this statement is a testimonial or not. So if a person made a statement, if the primary purpose of the statement is to identify the perpetrator, and then that would be testimonial, and then we would have this confrontation clause issue. In this particular case, in this Bryant case, the ruling of the court was the victim's statement was to the primary purpose of the victim's statement was to enable police to provide emergency assistance. So it was not testimonial. So admitting the statement would not violate the confrontation clause, because we know if that was not testimonial, we would not have this confrontation clause issue. So the ruling in this Bryant case was the statement was not, the victim's statement was not testimonial, so they would not, admitting the statement under this hearsay exception would not violate the confrontation clause. To understand what is the testimonial and what is not testimonial, the court in the case also discussed two cases. Both cases are domestic violence cases. And in the first case, Davis versus Washington, this victim made a 911 phone call, and then over the phone, she said her girlfriend was jumping on her, and also the boyfriend was using his fist to hit her. So the court said this is a very good example to show this statement was not testimonial. The primary purpose of this phone call and also this statement was to try to get police assistance. It was not the victim was trying to identify who was the perpetrator. But in the next case, in this Hammond versus Indiana, there was also a domestic violence case, and then the 911 call was made, and then the police arrived at this household where this happened. But at this point, this incident actually was over. And then the police asked the victim to fill out this affidavit. And then in the affidavit, the victim actually wrote that her husband actually broke the furnace and pushed her down and also attacked the child and so on and so forth. So the court said, in this situation, to write something in this, to fill out this affidavit, this statement made in the affidavit was testimonial, because the primary purpose was to identify the perpetrator. So for this statement to be admitted, there would be a confrontation clause issue. Actually, that would in violation of this confrontation clause. So it is important for us to make distinction between what is testimonial and what is not testimonial.